Hello, good day everyone. My name is Ron Lasco from International Trade Council, and I would like to welcome you for today's educational session hosted by International Trade Council. I am delighted to be your moderator for today's session. Before we start our discussion, let's take care of some quick housekeeping. Firstly, can everyone hear me clearly? If you can hear me, please type in yes in the chat box. Can anyone from the audience hear me clearly? Please feel free to type in yes in the chat box. Thank you. Thank you for that response. Excellent. Now let's ensure that everyone can see the presentation and slides. If you're experiencing any issues with our audio or visual, please let us know in the chat box and I will assist you promptly. So it seems that everything is running smoothly. Just a quick reminder for our attendees, if you have any questions during the presentation, please feel free to type in your question in the Q&A box located in your webinar interface. We'll address as many questions as possible during the Q&A session following the presentation. So without any further ado, let's start today's educational webinar. Our topic is how do you monetize a patent successfully? Fundamentals for patent monetization. Our speaker is Anders Arvidsson, CEO and founder, and Lucia Alvarado, partner of Parallel North IPAB. Today's Today we'll explore the fundamental aspects of turning in your patents into profitable assets. We'll cover key topics such as identifying market players, understanding different types of transaction, and essential steps before and after deciding to monetize a patent. You'll also learn what makes a patent portfolio a strong candidate for monetization through insightful case studies of both successful and unsuccessful business cases. Please join me in welcoming Anders Ardison and Lucia Alvarado. Go ahead.
Thank you so much, Ron. My name is Anders Arvidsson, and I'm the founder and CEO of Parallel North IP. Today we will give you a short introduction to the world of monetizing patents, and there may be other IP that may be relevant as well, but we will only focusing on patents at this seminar. We will first go through an overview, and then we will have the patent sales market and how it has developed during the years, and the basics of how you monetize patents, and give you some practical examples, and then we will end with some conclusions and Q&A. About our company, we founded that in 2016. And it's headquartered in Sweden, where I'm based, and then we have other business partners in US, for example, and in close by to Denmark. We do IP advisory, IP evaluations, monetization, also including an M&A advisory, and sitting in a number of boards. I have a background as a patent attorney. I started as a patent attorney in the beginning of 90s. For private practice. Then I moved over to Nokia, where I was still an attorney, but became the head of all the patent acquisitions at Nokia at the time, and was involved in a number of divestitures, licensing projects, and so on, that was relating to patent monetization. After that, then I was recruited to a private practice again, and started up a business unit for the private practice clients, doing patent monetization, licensing, buying patents, selling patents. Then I joined a mid-sized Danish company called GN Store Nord, where I was also VP for the IPR department. And then I became independent in 2016. We also have Keith Woomer, who is another business partner that is located in the US, Delaware. He has a similar background working for companies like Bell Labs, Agere, Lucent, AT&T, and his last employer was InterDigital, and he has been also orchestral to monetize IP through different licensing projects, patent sales and acquisitions. Then I will stop there and let you get an introduction of yourself, Lucia.
Thank you, Anders. Hi, everyone. My name is Lucia Alvarado, and I'm based in Copenhagen, Denmark. A little bit about myself. Well, my background originally started off as being in business and marketing. I started working in an investment firm developing technology platforms for banks and card processing. Then, about 15 years ago, is that I decided to move into the IP space. And I've been working on it ever since. My experience there started off in an American firm where we advised entities and also in their acquisition processes for licensing, most of it through enforcement. So that was very active business that it was back, some years ago. Then I did a research project in Nokia, and it's when my path and Anders joined the company to form Parallel North IP. I have experience in acquiring patents, licensing patents, and selling patents, and I've been doing that in the US and Europe. And also, I have experience in Latin America because I am originally from Nicaragua, but I've been living in Scandinavia for the past 15 years when my career moved to the IP space. So to start off with our presentation today, we want to give you an overview of monetization of patents. But first, what is patent monetization? Well, let's start with the definition of monetization. To monetize means to cash something into money or other source of profit. Well, therefore, patent monetization refers on how you transform patents into some source of value for the patent owner. It might be cash or it might be other type of value. But how do you do that? Because as patents are multi-layered assets, and there are different paths that you can take. You can either sell patents, and of course you can do it for cash or in the immediate term, or for other type of value. You can also buy patents, which you might do so to enrich your current portfolio, or you can license, which is a little bit more complex because you have, in general terms, two paths. You can do soft licensing, meaning that you do it without litigation, or you do it with enforcement. As the word says it, you put some force to it, and then there is litigation. Litigation is prevalent in the field of patent monetization, as you will see in further slides. So how well do patents perform? Well, we have seen that patent monetization has changed. It started off, of course, since the 1970s, we have data about global IP royalties and licensing fees, but that has increased over 100 times over the past 40, 50 years. In 2018, it surpassed 350 billions. We have seen that patents are no longer in the exclusive domain of lawyers. We do know that patents are a legal document, yet the monetization of them needs to be a combination of business, technical, and of course also legal. We are also seeing that patent owners are more and more realizing that patents are assets that can be monetized. They are expensive. It is difficult to maintain a portfolio, even if it's a small one. And therefore, they are looking into new sources of revenue, and patents is a way that they are turning into. And of course, there is a buzz. We see in the news deals, we see litigation, we see settlements. So that buzz provides more familiarity and awareness to the field. So in our experience, what we are seeing is that patents are being more used nowadays, both as defensive tools as well as a source for profit generation. Patents are growing continuously. According to WIPO, in 2022, there were close to 1.8 million patents granted. So year by year, we have 1 million average patents more into the pool of available patents. The growth that you can see in the bottom in the bars is also very high. Look, the change in 2021 was almost 10% growth. In 2022, almost 4%. That is a lot of patents being brought into the market, which is a possibility of them to be monetized. Yet, While over 1 million patents are being granted every year, only 5% of them, approximately, are monetized. We saw the number back there about the $350 billion generated. And if that comes from only 5% of the assets that are available, then that shows that there is a big opportunity. But why is it that this percentage is so low? Well, one of the answers is that monetizing can be challenging. When it comes to having a patent and then a patent owner has the idea, all right, I like the idea maybe that I would like to monetize, but what does it mean? How do I do it? Do I sell? Do I litigate? Do I license? How to proceed? There are essentially problems of awareness. We have problems also of funding. You might like the idea, but where do I get the funds to actually do it? About expertise on how and which resources are needed to proceed. And I think that a good way to understand and address this is to look at the patent market and the market players that are involved. So let's start with the basics. The patent market is formed by buyers. So who is buying patents? Operating companies. We're going to use this term along the presentation, and opcos or operating companies are entities that basically have products or services offered in the market. They might be micro, small, medium-sized entities to big corporations like an Apple, a Google. So any entity that has a product or a service and also has patents are going to be treated as an operating company in this field. Then we have non-practicing entities, or NPEs. Well, this is another very important term. These are entities that acquire patents or develop them in some cases with the intent to license them. In most cases, through litigation. Litigation, again, is prevalent in the field. And then we have patent aggregators. These are a type, actually, of a non-practicing entity, because what they do is that they develop patents or acquire patents to put them in a big group of assets and then license them out in a sort of membership. So any entity that takes a license to that big portfolio that these companies have aggregated gets access to that portfolio, and most of the time is for defensive means, meaning that they use the assets in that portfolio that the aggregator provided as a shield. Then we have the sellers. So who is selling? Who is putting the assets into the marketplace? Most of them operating companies. As I mentioned before, the Googles, the Apples, the Samsungs of the world, the HPEs, IBMs, etc. Non-practicing entities, sometimes they also divest assets. We also have universities and research centers. It is curious to see that entities like these organizations have a lot of patents, but it's not very common to see assets of them being monetized in the marketplace. It is more common for universities to license out their portfolios in the US, yet is not prevalent elsewhere. And then we also have another seller, which is individual inventors. We have actually a lot of experience with inventors have reached out to us to monetize their assets. And then how do you bring these together, the buyers and the sellers? Well, you have the intermediaries, the deal makers. These might come in the form of advisories or brokers, financing, law firms, or a mix of it. But it's important to see not only the players around here, but their motivations. So buyers are motivated to buy because they want to use the assets to monetize them, to get value out of them through licensing or enforcement, or also, again, for defensive means, or also in some cases to access a new technology. I would say that the top two, in our experience, are the strongest. The sellers. So patent owners are motivated to sell because they want to get money, because they want to avoid litigation, given that sometimes these are used as a bargaining tool in negotiations. And then ultimately, the intermediaries, the deal makers, they have an extensive network of buyers and sellers. They're bringing them together, and they are incentivized by the highest bidders. I'm going to pass it on to Andres to talk a little bit about the patent sales market.
Thank you, Lucia. So, giving the basics for the patent sales market helps you a little bit to understand the following slides here. There is this slide present the total market of all the patents that are available, and the pricing here is based on the asking prices. The data has been collected from both brokers, but also from private deals that has been available. So during the time here, you can see that it has been developed quite significantly in matter of pricing. So we have up to this year, we have about 44 billion US dollars in asking prices based on the patents that has been available on the market. But the sold assets, which is based on the assignment histories from the patent offices, you can see that there was about 12, 13 billion US dollars that was sold, corresponding to the value of asking prices. Then who is selling? Lucia, you introduced the terms here like operating company, the abbreviation OPCO, the non-practicing entity, NPE, and they have the defensive aggregator and others that could be research institutes, individual inventors, but also finance institutes like banks sometimes. So this presents the who is selling and what has been sold and not sold. And you can see that the operating companies, they have been quite successful, but the majority actually was from others in this aspect. Not surprisingly, the MPs does not sell so much, perhaps, as they buy, and the defensive aggregator who has acquired patents was not so successful because they are quite heavily encumbered through licensing, and the value has been quite diluted. You can see that one of the major sellers is actually a defensive aggregator called AST, Allied Security Trust. And then you have operating companies like HPE, you have Huawei, Intel, GVC, Knowles, and Philips, Nokia. And then you have Ofino, that is a non-practicing entity that develops their own IP, but they have chosen to sell instead of licensing. Then you see the buyers and the distribution of buyers during the years between 2018 to 2022. And you can see that there is a trend from the MPEs that they are buying less and less. 2020 was peaked, but then in 2022, there were a lot less. So you can see that there is a trend for defensive aggregators and operating companies to buy more patents in order to avoid litigation and have a reasonable way to control the flow of incoming patents. And the buyers, you can see here you have, for example, ADC, but you also have AST that was mentioned in the previous slide, Xiaomi, Comcast, Crowdsource, Hyundai IP Value Management, which is a very aggressive MPE that has been acquiring patents a lot, and they have probably the highest litigation rate now in the US. Philips is another one that buys patents. Palo Alto Networks, Peace Future, RPX, Rational Patent Exchange, which is another defensive aggregator that buys patents but don't sell that much. Samsung and Workday as well. And this slide present the asking prices, and it is a little bit. It should be a little bit carefully reviewed because you have asking prices, as you see, per asset, and you also have the asking prices per sold asset. And then you can see that there is a huge gap between those two. But then you can see, if you look at the inflation as well, which is actually quite a lot. And the prices here, can you say that the summary is that the inflation has not actually taken care of the prices. So it is a little bit sad that it hasn't actually been adjusting according to inflation. And so the conclusions is that the market for patent monetization, it is big and it's growing. You have owners that is turning more into patent monetization, meaning that they are more aware of it. So there's an awareness in the market. You can also see more structured deals, meaning that they will be more sophisticated. And one thing that is key in this market is that you have high quality assets. So what we mentioned before, the FBs are more selective, and they only, if they see that the risk is too high, they will back out normally from a buy to buy the patents. And as you can understand, there is a lot of work that needs to be done prior to putting the patents to market in order to avoid any questions or issues that may occur later on when you're closing the deal. And you can also understand maybe that there is a lot of patents on the market, there is less being sold. So it is a buyer's market, and it's also very difficult to penetrate the buyers. So that's why you need to have that you can see that there is a need for a middleman as well. Prices go down, and that is what we can see, perhaps also because of the market situation in the world. But we can see that there is a more structured market. You can see that there is a lot of more healthy deals that was made in compared to what was made in the past. So getting back to why the middleman or the intermediate has an importance is that the data that you saw here, based on both private deals but also on the broker deals, you can see that the brokers represent here per patent is about 70%. But then if you look at the packages, which consist of a number of patents that were sold, so that means that 87% of all the packages were also represented by brokers. So we do have a significant impact on the market here.
Moving on to patent monetization possibilities. So how do you go from the idea, I have a portfolio, I know I have questions, what I want to do is get to this deal, get a settlement, get some money. How do I do that? Well, it is challenging, but there are ways to address it, and we can share a little bit of our expertise. So what's needed? First of all, you need quality assets. Quality, of course, is subjective, but in the marketplace for monetizing assets, patents, where your product is the patent, it's important that you have good technology, ideally already implemented or infringed. We're talking here that your product is a piece of paper that is providing monopoly for 20 circa years. So how do you make that really shine? You need to know your claims. That is key, and I cannot stress it enough. Often we come up with experiences that we have an idea in our heads about our technology. And sometimes technology and patent claims do not necessarily match. You need to understand what those words exactly say in the claims, because your patent is only that, no more, no less. And also, it's important that you look at jurisdictions. When monetizing an asset in this marketplace, we patent buyers normally look at the important jurisdictions in the field. Number one, US. Number 2, Europe. Important to look at which European countries are covered. Ideally, you have the big ones, right? You have Germany, France, the Netherlands, the UK. It's also important to look at the date. You want to have a good balance of an early priority date, yet not so early, right? Because you still want to have some life of the patent left, but you still want to have a date that is one of the first ones in the field that has coverage for X technology that you have. It's also important that it covers an extensive market and that it's profitable. Sometimes there can be great patents with great technology, great claims, great jurisdictions, yet there's no market. Therefore, the value for a potential buyer or licensee is fairly low. Then what else do we need? We need to do our homework. Before you go to the marketplace, you need to know your technology. Again, I cannot stress enough, know your patents. Your product is a patent, know it. Print it out if you have to. I'm the type of person that likes to read a paper, so I highlight and I read the claims, go to the specification. How does the specification support my claims? What other patent family, what other assets enter the family? Is there anything in prosecution that might hurt me or benefit me? You need to know your market also. You need to understand where do you stand? What type of technology is it? And what is my position? What is my value chain? And that will give you something that is crucial to understand. What is the added value? Because no one wants to buy or license something that is not needed. So why is this valuable? And you need to develop a tailored strategy, and you need to communicate it clearly, depending on who it is that you are contacting. Which brings me to the next element, which is network. It is extremely important that you have the right contacts, so you reach out to the right person at the right time. Timing is key. For example, we understand that companies sometimes are in the process of closing budgets. So sometimes it is a good time to propose them a deal before they close their budget. Sometimes it's not a good time because we know that their offices are closed during X time of the year. And examples like that. So that is something to take into consideration. When you have found the right person to contact, you do it at the right time. And then you have a tailored message based on the contact. So who is my audience? Is my audience a person that understands or likes to hear more about technology? So I focus on that. Or is it a person in finance? So maybe they're looking more for cost savings or revenue generation. What is going to make them tick? So it's important that you know and you tailor that message to them. And use the right channels. Sometimes it might be an email, a call. How do you package that information so that it catches their attention? How do you make an email not go to spam? How do you make them pay attention to what you're offering? But if you look at all the aspects that I've mentioned here, you have done your homework on good assets and you contact the right people, then you are in the path of success. And a last point that it's very important, as Andrew mentioned before, is to find a right partner. Large corporations, small corporations, they all have seen in our experience that they find partners to do the monetization process. It might come in the form of legal, business, technology, a mix of them. But it is important that you find the right partner that is going to help you package this, understand this, and reach the right audience. Anders?
Sorry, I was on mute. So yes, thereafter you need to decide which way you should monetize your patents. And I think, Lucia, you also mentioned that in the beginning, there are different ways to monetize a patent, and the most obvious one is to sell the patent for a lump sum. The second normal or usual way to monetize a patent is through licensing and establish a licensing campaign. And the last one, which is a hybrid of both, is that you find a buyer who would like to monetize the patents and license them, and then you will get a cut from the licensing revenues from the buyer. There are certain facts that you need to consider, or parameters, that is added to each of these ways to monetize patents. You have a certain way of complexity. You have the investment risk as well for you and for the other ones perhaps, and the risk of success or failure, and how high the return will be. So looking at first the opportunity of selling, it is rather straightforward. There's low risk of complexity. You have transparency when you're offering a patent on the market, and the investment is low. The only thing that you will invest normally is to actually find the time and resources to find the right buyer. The risk, well, it is that you have a failure of not finding a buyer, so then you have wasted your time perhaps. The possible return is that you will get the money up front, perhaps not as much as licensing. It would be for licensing the patent, but you will have a shorter time period. When I look at a licensing campaign, it is rather complex, meaning that you have a lot of factors that could lead to a failure. The investment is rather high because you probably also need to consider how to defend your patents through enforcing them by litigation. Because there are a lot of companies that choose not to license patents, even though they seems to infringe. So it's a matter of interpretation, and some larger corporations actually have it as a standard to fight it in court rather than to take a license directly. So there's a high risk that is involved in here. However, the return is also high, but it's something that requires a lot of funding and experience as well. The hybrid for you as a patent owner is less complex, but it still adds some complexity because you will get some money perhaps upfront. Sometimes you don't, and you don't know if the licensing entity that acquired the patents will be able to successfully to find the right licensees. The investment, well, it's you giving away your patents. You don't know if you get a return or not. So obviously there is a certain risk involved for failure as well. But the return is much higher normally than selling the patent directly. But you will need more time in order to and be patient as well and support the partner that has acquired the patents for you. So what you would need in order to succeed or increase the likelihood of succeeding is that you would need to do your due diligence and your homework, as Lucia said before. You need to identify what kind of prospect buyers there would be, what would be filling your comfort zone. Um, how do the patent landscape look like? Meaning that you can identify potential prospect buyers that is aligning with the technology area or market that would be relevant for the patents that you are going to market. Um, and in best cases, you have a market which is mature. You can also see the potential value of the market and the products that is out in the market. In best case, you can also see that there is a potential infringement. You can create claim charts where you provide evidence of use and identify the prospect infringers, but also potential buyers. The valuation you can provide in this aspect, depending on if you're licensing or if you're selling, is quite high. in respect of expectations. So if you're licensing a patent, then of course your expectations would be higher than you would in order to sell them, because the risk is much higher for licensing than selling a patent. So then you also have the IP assessment. I mean, you need to have all the facts and the legal aspects of the patents clear, and you need to present the clean slate for the prospect buyers, like you having factors like ownership. Has it been assigned? Is the assignment history intact? How is the priority date and following the family members of the patents, and so on and so forth. So there is a lot of things that you need to keep in mind. And then from the sale, you need to see what kind of deals that you would like to structure. All buyers are different, and all deals are different. So you need to be flexible and adjust to the possibility to close the deal. And marketing, of course, that is important. There are ways to market a patent in various ways, and historically, you have had patent auctions. You have had larger sales, which nowadays is very rare because of the success, being that people or buyers are more selective. So what we do normally is that we have a direct approach through our network to identify the prospect buyers and who would be the most responsive person to actually look at this and see that this is an interesting opportunity for the company that would like to buy or license patents. And of course, negotiations and deal making is a big part of this, because you need to have some experience, need to understand what kind of terms you have in an agreement, and some can actually mean quite a lot and may be dangerous for you as well for future opportunities if you are not careful and have the experience from making an agreement with a potential buyer.
So, a suggested approach that we have, and this is basically a process that we take internally when we have cases. A patent owner comes to us and they say, I want to monetize my portfolio, be it through sales or licensing. First thing we do is to do a patent and technical review. Again, review your claims, understand what it is, and then match it up to technology that's out there in the market. Then we do a market review. Who else is doing this? Who's relevant? How big is the marketplace? Is it growing? Then we do a patent landscape review. Remember here that our product is the patent. So we want to look at what other products are out there like mine. This we can do by similar codes, by keywords, by a name of patent owners that we have identified in the market analysis. And we take different approaches to understand what is the patent landscape of assets similar to mine. So you start gathering information from the patent, from the market, from the patent landscape, and then you do an environment review, meaning who are the stakeholders? Is there anything important to consider? Do I have any regulations to think about? Is it a standard? When is it going to be implemented? Is it going to be a new implementations in the future? So we look at that and the stakeholders. Then we do a network analysis. Okay, who do I know? Who do I know that knows someone? How do I reach them? And then we do a value proposition. Why would these entities that I have identified that I can offer them this beautiful package with this great technology, with these great claims, which I have mapped to a product in the market? How do I really make it highlight? What is the added value for them? That is the most important question of it. Then we develop a tailored strategy to communicate that message, that value proposition, and we make it look very nice in a marketing package to share it with them through the means that has been identified as the best possible for that specific contact. And then you do the outreach. You go knock on doors. Well, not necessarily needs to be a door, right? It might be a call, it might be an email, it might be in a conference, it might be in a meeting, but it's important that you limit your outreach to the entities that are specifically important for your case. We have some practical examples, some cases that we have seen. We're going to present to you two. The first one that we have is a licensing campaign. This is one that where Parallel North IP, we were engaged as the exclusive agent to license out a huge portfolio. You, of course, have heard of Kodak, but Kodak had almost 5,000 assets, and they were looking to license it out to entities outside of the camera space. Maybe that space has already been licensed before. But what happens to the technologies that can be used in vehicles, camera manufacturers, optics and medical imaging, smartphones, e-commerce, etc.? So our objective was to take a soft licensing approach. What that means is that we wanted to do this as a business proposition where there was a win-win without litigation. And it was our objective to focus on the value of a portfolio for them. So timeline here. Unfortunately, I cannot share specific details of the deals that were closed, given that it's confidential. That is something that you will see it's quite prevalent in the space, that most of the information is confidential. But what I can share with you is that we started this campaign in April. We were signed as the exclusive agent, and by November, we have signed Nokia. And then along the next 6 months, we managed to close 6 deals. And how did we achieve this? Again, we follow that approach of understanding our patents, our technology, our market, and focusing on the value proposition.
Then there is another example here, not a licensing campaign, but just a sale, patent sale, where we were representing a company called Exylon. It's a Dutch company which has developed a receiver in the ear, hearing aids, which has a microphone in the ear canal. And they have done self-fitting tests and mechanical construction, such as pull members for easy removal of hearing aids from the ear. So it's a very specific technology area. The portfolio, they had about 30 plus patents and applications. And we reached out to a number of prospect buyers. So if we look at the next slide, we can see the timeline for the sale. So in June, we signed the agreement with Exylon, and we contacted about 20 prospect buyers until November. And in February, we received some offerings from various companies, and they did their due diligence. And then in May, you can see that the patent purchase agreement was negotiated, and there was a closing of the agreement in August. So the timeline here, well, normally we have an agreement for 12 months, a year, but here you can see that it extends over for 12 months as well. So that is typically the sales period for patent sale. And the acquirer here was called HIMP. It's a consortium of hearing aid companies that went together and made a cumulative bid for the portfolio, so we could have an interesting competitive bid as well for the closing. So the conclusions here that we have learned hopefully today is that there is a market for patents, and they can represent a very high value, but it can also be worth nothing if we are not selling it, of course. But if we don't go out to market, then of course that we would never find out either. So it takes time. It is something that you have to be very patient, and you have to be transparent, but also listen to what the prospect buyers would like to buy, and it's not necessarily always what you think they would like to buy, but what they need sometimes. And the risk of obviously from not selling or closing a licensing deal, litigates can also fail as well, of course. So, and the patent may be invalidated. You may end up in ownership issues. So there's a lot of things that you need to consider before getting into market. But also, when you're in the market, you can discover things on the way that you were not prepared to that would occur. So being flexible and creative, that is the key. And also, as we have said before, do your homework before entering the market and before you're contacting companies as well. So, I mean, if you contact companies too early, then they may not perhaps respond to you the second time that you approach them, if there would be a more mature patent on the way that you would like to offer. So be patient, diligent, and things will be successful if you're going to monetize your patent. So thank you. And I guess that Ron, you will now moderate the Q&A session here after the presentation.
Yes, thank you so much for that very informative presentation. We have several questions right now, but before we proceed with the questions, I would like to make some few announcements. So this webinar is recorded, and if you would like to review or replay, you can visit our YouTube channel, International Trade Council. In the next few days, we will upload the recording. For the PowerPoint presentation, Anders, is the PowerPoint presentation can be shared to our audience?
Yes, I can send a PDF version to you, Ron, after
Okay.
the presentation here.
Sure. Please, for those who are interested to have a copy of the PowerPoint, please feel free to reach out to me via email. And you will be getting a certificate of participation for this webinar in the next few days. And lastly, if you are not yet a member of International Trade Council, we are offering free membership for attending this event today. Just please feel free to email me if you are interested. So we'll start with a question. So first, we have here how to estimate the value and the price of the patent.
It depends. So it means if you know if you have a patent that you're going to sell, then there is a different market price. For example, if you're going to license the patents, so the expectations are different. So if you have a patent that where you have claim charts reading perhaps on a standard, um, that could be worth quite a lot. But even though the if you would monetize it and you could put up a business case and the business case would reach 10 20 million US dollars, it doesn't mean that that's the price. So then it may have to be discounted. So perhaps 1 million would be reasonable, because then you also need to understand that the investor needs to put a lot of money to enforce the rights in order to get the money back. Um, but then there may be also other ways to where there's a need to value a patent. For example, if you sell a patent to another country, then you have transfer pricing legislation that where you have an obligation to the tax authority to do a valuation, even though it was a patent swap, meaning that you were exchanging patents or you're moving a business abroad. Then you're transferring the patents abroad as well because of the ownership. So then you have to record and do evaluation for the assets that is being transferred. So to answer you, yes, I mean there are different ways, but it's the value is depending on the need for doing the valuation.
All right, thank you. And the next question here is my question is which category of entity, manufacturing sectors or services sector or both can be qualified for patent market? Please clear it.
Lucia, would you like me to take it, or would you like to go for it?
Yeah, let me see if I understand the question, is which category of entity, manufacturing sectors or services sector, or both can be qualified? Both. Um, Depends, it can be both, it can be a mix. You will see, okay, let me put it this way. Most of the patents are going to be for products, yet it does not need to be for a product per se. You have patents that cover also methods to do a product. So, and it's also sometimes a method to perform a service. So it can be both. It doesn't necessarily need to be for one category. It can be a mix. And sometimes it is a product, the actual technology, yet the patent is not for the product, but is for the method or the process on how to do it. So it is not limited to any of it. Maybe one remark to mention is that when thinking about hardware and software, this is a good distinction to make because at least in the US, which is the biggest market for patent monetization, hardware patents are the ones that are the most sought for. Because of legislation in the US, software patents are a little bit more difficult to monetize. Yet in Europe, that is a different situation because their legislation does not limit. So I think that I extended my answer there with the hardware and software, but I thought it was an interesting add-on to the question. I hope I managed to answer it.
Thank you, Lucia. Next question here. When we should think for monetization after filing or after a grant? Well, I think this is
Okay.
when we should monetize it, after filing or after a grant. Maybe that's the question.
Yeah. Um, I can take that if you like. So when you have a file a patent and it's pending, you need, well, then you have the examination process, which may also change the claims or scope of the claims, meaning that it would be a risk for you as an investor or buyer to buy a patent that hasn't been granted yet. So in order to increase your probability of selling a patent, it is actually not bad to wait if you can afford it, and perhaps, yeah, see when the market could mature as well, because a patent is also based on um, on on an invention that has been not been commercialized yet from the beginning. So it normally takes a couple of years, and if you could connect a revenue stream to the patent, then it's maybe valued to be a much higher value for you. So it's difficult to say when, but sometime it may take 10, 15 years. Sometimes it may take less, but at least a granted patent has a higher probability of being monetized than a just patent application.
All right, thank you. Next question. How can we give value to our patent?
Okay, I can take that one. Okay, so how can you give value? So adding more value to an existing asset. Well, the patent is only what it's stated in the claims. So that is what your patent covers and what you can monetize, and the value is based on that. What can the value to that on top of it? Something that can be done. You can increase the family if it's a possibility. You can keep on prosecuting and add claims that focus, if possible, based on the date, focus on technologies that are going to be implemented that add value from a market perspective, an implementation perspective, and a user's perspective. I think it's important to think about what makes a patent valuable. First and foremost, looking at the patent monetization market, an infringed patent is the most valuable patent. No one wants to pay for something they don't need. And the way to show need of a patent, the easiest way is through infringement. So you can add value to your patent by identifying infringement, making sure that your patent family is strong. Look at your claims to make sure that they're pair up to what's implemented in the market. And absolutely, again, do your homework. That adds value to your case because a patent is just a piece of paper. And in order for you to sell it, in order for it to shine or to license it, you need to dissect it, understand it, and highlight the added value.
All right, thank you for that, Lucia. So we still have a few questions here. We only have 5 minutes, but let's. I will allow the last three questions to be answered, and if you have any more questions about the topic, please feel free to email our speaker. So next question here is here you go. What's the best jurisdiction for the patent?
Well, the most developed market so far for patent monetization is the US. But you can see that Europe is also increasing interest. Uh, Previously, the European Patent Convention has been, well, it's been successful for many years, but the difficulty here is that you have national patents. That means that you have to enforce the patents in each jurisdiction of the European Union or Europe. But now they have the unified patent courts, meaning that you can choose for having a EP patent or a UP patent. So if you have the UP patent, then you have one court to go to enforce all the jurisdictions in Europe at once, which means that it will be or has been quite competitive against the US, which is the whole idea. So I would say that Europe is increasingly in the importance of a jurisdiction right now. Then you look at the other jurisdictions, of course, you have China, but it's also very difficult to enforce patents, even though the value of the enforcement has been increasing. There are other jurisdictions as well, but I would say that the most mature jurisdictions are Europe and US.
All right, thank you. So next question. If a patent owner in Europe were to assign a patent to me in the US, does the patent ownership also transfer, or do I have to submit a patent to the US Patent Office for ownership and protection?
Okay. So that's an interesting question. And the jurisdiction of the patent is set when the patent is filed. There are different ways to file the patent depending on the office that you go. But normally, the jurisdiction is set and it can be decided only during some months in the beginning of the application of the patent. So if a patent owner in Europe assigned a patent to you in the US, does the patent ownership also transfer? Well, yes, but it depends on what's written in the agreement. It depends. Is it a portfolio that contains assets US and Europe? Normally, and it was extremely recommended to transfer all assets in the family, even if it's jurisdictions that you're not going to use, because it can be turned really messy if some of the assets in other jurisdictions are not transferred. So we would recommend actually that is to be written in the agreement when there are transactions that all the jurisdictions are passed. And if we're talking about the idea of a patent that is going to be during the application process, then that is to be decided by the person or entity who is doing the actual application. And then the jurisdictions need to be decided. And then if it's going to be transferred at that time, then absolutely, again, it goes again to what I recommended, that all of the assets in all jurisdictions need to be transferred.
All right, perfect. Thank you. Next question. When you approach companies, should you suggest to wholesale with your current manufacturer or give them permission to find their own manufacturer?
Not sure if I understand the question correctly, because I mean it's not a matter of manufacturing um, and selling patents. But yeah, do you know or
I can think of I mean, I'm not sure if this will answer specifically, but if you have a patent that is covering something that has to do with manufacturing, and you're going to license that patent so that an entity can manufacture what's covered by the patent, then it is up to, and talking about that assumption, right, that you have a patent that is covering something, either a product or a service or a method dealing with the manufacturing, then you grant a license for that patent, and you can decide, depending on the negotiations that you do with the entity that is buying or acquiring the buying or licensing the patent, if you're going to have a say in who manufactures. It depends. I mean, Andrews presented before some hybrid type of deals where you have a patent and then you sell it or license it for then someone else to do the monetization of it. So maybe we can apply that same concept to this, but to the idea that you're going directly to the product market per se, not the patent market. But that depends on the deal. And I would say that in most cases, the you would not have a say in who manufactures. You could have some suggestions, yet the decision maker is the one that's putting the money.
All right, thank you. So we still have one question here. Maybe let's just finish the last question if it's okay. Um, 1 second. Okay, the last question. Can country patents be sold individually granted? For example, Japan within healthy inhalation that meets addicted smokers' needs for a natural anti-addictive hit.
sure. Patents can be sold individually, even though you have a patent family where you have individual patents in different jurisdictions. However, it's normally that you will offer the whole patent portfolio, meaning that you have the whole patent family, even though you have different jurisdictions. But it depends on case by case, of course. But it's nothing that I see would prevent it.
All right, thank you. So that's a wrap our question and answer for this educational session. If you have guys any more questions, please feel free to email our speaker directly. So maybe Lucia or Anders, please type in your email address here in the chat box so that they can copy it and they can reach out to you if they have more questions.
Sure.
All right, perfect.
Yes.
Thank
Thank
you.
you, Lucia. So before we end our educational session, any final words from Anders and Lucia?
I think it has been very nice to have the opportunity to present the introduction of patent monetization. And thank you for being here and hosting the meeting, Ron, and ITC,
You're welcome.
International Trade Council.
Yes,
Lucia?
same here. Thank you, ITC, and thank you, Ron. And thank you also to all the people that have joined us today and for all these great questions. If anyone else wants to have further information, please do reach out to us, that we're happy to help if possible.
All right, that's a wrap. And we appreciate your time today for attending this educational session. Thank you, Anders and Lucia, for sharing your knowledge and skills about the topic we discussed today. Thank you for joining everyone to our webinar, The Basics of Patent Monetization. We hope you now have a better understanding of the market players, types of transaction, and steps involving in monetizing a patent. We trust that the case studies and insight shared will help you make informed decisions about your intellectual property. If you have any questions or need further resources, please reach out. Have a great day, and we look forward to seeing you in our future webinars. Have a great day, everyone.
Thank you.
Thank